If you walk into almost any high-end mall in America, you will find a trendy clothing store that caters to fashionable teens, Abercrombie and Fitch. Abercrombie's young sales associates are called models. Abercrombie's look policy requires models to showcase the Abercrombie style to customers. The look policy specifically bans black clothing and caps. In 2008, Samantha Elowoff applied to work at an Abercrombie kids store while wearing a black headscarf. No, not that kind of headscarf, this kind. As a practicing Muslim, Elowoff wore a headscarf every day. During the job interview, neither Elowoff nor the interviewer discussed Elowoff's religious beliefs, look policy details, or Elowoff's need for an accommodation from the look policy. However, the Abercrombie interviewer correctly assumed Elowoff was a Muslim, wore a hijab as an expression of religious faith, and violated the look policy. On those bases, Abercrombie declined to hire Elowoff. Abercrombie has granted exceptions to its look policy for hijab-wearing Muslims. The Equal Employment Opportunity Commission, or EEOC, sued Abercrombie on Elowoff's behalf and claimed the company violated Title VII of the Civil Rights Act of 1964 when it declined to hire Elowoff based on a religious observance or practice. Abercrombie responded that Elowoff should have asked for a religious accommodation. A jury sitting for the limited purpose of determining damages awarded Elowoff $20,000 in compensatory damages. The 10th Circuit reversed and granted summary judgment to Abercrombie. Critically, the 10th Circuit found that Elowoff never informed Abercrombie that she wore a hijab as an expression of her faith and that she needed a religious accommodation. There is a circuit split on the question. Only the 10th Circuit requires actual notice from the employee. The 7th, 8th, 9th, and 11th Circuits all impose liability if an employer has constructive knowledge of the need for a religious accommodation. The government makes three primary arguments in urging the court to reverse the 10th Circuit. First, the government argues that Abercrombie intentionally discriminated against Elowoff when it correctly perceived that she wore a hijab as a religious expression and refused to hire her on that basis. Abercrombie responds that it simply applied a religion-neutral employment policy, and its conduct in this case falls woefully short of the standard for intentional discrimination. Second, the government urges the court to reject a rigid notice requirement for religious accommodation claims. Citing the EEOC's own regulations and guidance on this matter, Abercrombie urges the court to require employees to raise the need for a religious accommodation. Third, the government argues that Abercrombie, which alone had complete knowledge of its own employment policies, preempted meaningful communication when it acted on its suppositions against Elowoff instead of initiating a dialogue with her. Abercrombie responds that Elowoff, who alone had complete knowledge of her own religious practices, had the duty and obligation under federal regulations to raise the need for a religious accommodation. This case is significant because neither an employer nor an employee will always have complete information as to a possible conflict between the employer's policies and an employee's religious practices. With no significant and consistent knowledge advantage to either party, who should bear the burden of initiating a dialogue regarding the need for a religious accommodation? The facts of this case do not paint Abercrombie in a significant light. While Abercrombie argues that it simply applied a religion-neutral employment policy, the undisputed facts of this case show Abercrombie assumed Elowoff was a Muslim. Abercrombie assumed Elowoff wore a hijab as a religious expression. Abercrombie never discussed the details of the look policy with Elowoff. Abercrombie admitted that Elowoff was otherwise qualified to work as a model. In spite of all this, Abercrombie declined to hire Elowoff precisely because she was a hijab-wearing Muslim. And in the face of all this, Abercrombie admits it has granted exceptions to its look policy for other hijab-wearing Muslims and yarmulke-wearing Jews. The countervailing considerations are procedural, and the question before the court is procedural. In the fora below, the EEOC presented this as a religious accommodation case. Before the Supreme Court, the government now argues this is a case of intentional discrimination, which is a different legal theory. Abercrombie claims making an exception to its look policy would damage its brand. It is true that the statute relieves employers of liability if they can show undue hardship. One question here is how integral the look policy is to the Abercrombie brand. Are some businesses so hostile to certain faiths that devout people may not be accommodated in key roles? For example, if an Orthodox Jew applies to work as a server at Hooters but argues that her faith prohibits her from parading about in tawdry attire, must Hooters grant an exception to its dress code when its brand is built on the objectification of women?